You are watching the LemonAid podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hello and welcome to the LemonAid podcast with lemon law expert Shalev Amar. This is the show where we squeeze out the truth about lemon laws and help consumers navigate their rights when dealing with defective vehicles. I am your host, Kevin Rosenquist, and today we'll break down some of the most common reasons why manufacturers might reject a claim and the legal options available to consumers when they face this frustrating situation. Shalev, great to see you again. It's been a bit.
Hey, great to see you too.
So how common is it for manufacturers to deny a lemon law claim? And what are the most common reasons that they would do that?
Well, there's a variety of reasons. And as far as percentages, it really that's context dependent. So I would say, just historically speaking with potential clients and clients, if they're handling a lemon law matter on their own, the reject rate seems to be pretty high. I would say at least 60 to 70% if I had to try and quantify it.
Oh, wow.
For cases we take on, the reject rate is much, much lower. I would say it's probably 2 to 3%, if that, of the cases that we take on.
It's much better.
Yeah. And I would say it also kind of depends on the time of year. Sometimes it could be as low as 1% or even lower. And there's a variety of reasons why a manufacturer could reject a potential lemon law or breach of warranty claim. So typically the most common reason would be if there's an outside cause of the vehicle problems. So what are typical outside causes? A car wreck, an aftermarket add-on, abusing or misusing the vehicle, like failing to maintain the vehicle. Those are outside causes that could cause vehicle problems that are not due to defects in materials and workmanship. So those are the most common reasons why a company would reject a claim. A legal reason why they would do so would be if the claim is timed out. So every state lemon law, virtually all of them except for maybe a couple that I'm aware of, do have strict deadlines for when you could bring a lemon law claim. So that could be another reason, is if the claim is timed out.
When a manufacturer rejects a lemon law claim, what legal options do we as consumers have?
Well, there's several options. If the consumer has been handling the matter by him or herself, then the obvious next step is to confer with an attorney. I would say it makes sense to always confer with an attorney rather than to try and handle an issue like this on your own, because the companies have legally trained representatives or sometimes even attorneys who deal with these kinds of matters. And so you don't want to, basically go into a cage with a professional UFC fighter and you're not a trained fighter. That's kind of what it's like. So we recommend that any consumer who believes they are saddled with a lemon, they should confer with an attorney before even reaching out to the company. But in any event, the ones who do it on their own, if their case is rejected or the claim is rejected, then the next step would be to reach out to an attorney for a fresh set of eyes and evaluation. Because I can tell you, there's lots of times where people have come to us where they've been rejected or had their claim denied by a manufacturer, and it's a valid case, and we take it on, and we're ultimately able to resolve it for them. Now, let's talk about a situation when you already do have an attorney and the claim is rejected. Then I would say it really depends on why the claim is rejected. If the manufacturer has a legitimate defense, like let's say you got in a car accident and the problems that you're dealing with are due to the car accident. So let's say you're having a steering issue, but the cause of the steering issue is you were T-boned. And so that messed up the vehicle's steering mechanism. And so that would not be a claim that you could prevail on in court. So in that situation, if there truly is an outside cause and you don't have other defects, then my recommendation to people in that situation is to not take it any further, to just move on, either keep the vehicle or sell it or trade out. If the denial, however, is illegitimate, meaning that it is a valid case, it is for defects in material and workmanship where there is no outside cause, and the manufacturer is just being unreasonable and not accepting responsibility, well, that's a situation where you would want to look at escalating the matter to formal litigation.
And obviously, lemon laws are there for us, right, as consumers, to hold manufacturers accountable. What role do state lemon laws play in ensuring that for us?
Well, they play a vital role. So look, if it was up to manufacturers, most of the time they would do nothing.
Right.
If the manufacturers did right by their customers when they end up with lemon vehicles, and it's almost inevitable with mass manufacturing, despite best efforts, a certain percentage of vehicles are going to come out as lemons, is the way it goes.
Yeah.
Lemon laws help hold manufacturers accountable because what the lemon law does is it says at a certain point, enough is enough. Of course, you've got to give the manufacturer an opportunity to repair. It can't just be that you have a problem and you've never tried to get it repaired. You have to give them a chance. However, if you give them that chance and they're unable to repair the vehicle within a reasonable number of attempts or within a reasonable time, then at that point, like I said, the law says enough is enough. That is the accountability portion of the law. It says, look, at a certain point, basically when the repair history becomes unreasonable, and if it's in some states, if it's a safety related defect, it only needs to be 1 or 2 repairs because you're risking your life driving the vehicle. And in most other states, it's 3 or 4 repairs for the same issue, and the problem continues to exist, or 30 or more days out of service under warranty for the repairs, and that's within the lemon law time period, which typically is 1 to 2 years in most states, and in some states could be the entire duration of the warranty. And that's definitely the case under the federal lemon law. But in any event, what the lemon law does is it says, hey, look, at this point, you either need to buy back or replace the defective vehicle. And in most states, you also need to pay the consumer's attorney's fees if they hire an attorney. Under the federal lemon law, the most common type of resolution is what's called cash and keep, where the company provides cash compensation with the consumer keeping the vehicle. It's called diminution in value. And in layman's terms, it just basically means that you didn't get what you paid for it. You bought typically a new or a newer warranted vehicle. You really got the equivalent of a vehicle that's used and run down, actually roughly used, that should have cost substantially less. And so it's kind of a hindsight inquiry. What should your vehicle have really cost if the defects and the repair history that you end up experiencing was foreseeable? So, there's no specific formula for that. But again, new versus used is kind of the easiest way to look at that. And so that's the accountability under both state and federal lemon.
Are there other consequences for the manufacturer when a claim is denied? Are there legal penalties? Are there reputational damage? Like what are some of the things that can happen to a manufacturer who refuses to honor a lemon law claim?
Well, look, it does vary state by state. I would say at an absolute minimum, if it's a legitimate claim and the manufacturer gets sued and ultimately doesn't settle, fights all the way, and loses at trial, the manufacturer could have to pay a substantial amount of attorney's fees to the consumer. So we're talking about 30, 40, 50, depending on how heavily the case is litigated, even $100,000. Not just that, they're also having to pay their defense attorney or attorneys. And that could be an equivalent amount, an even higher amount in attorney's fees. And that's why it doesn't make sense for manufacturers to not try and resolve these claims out of court if you have an attorney, because they are facing major downside financial risk if you have a legitimate claim and they don't accept responsibility and you fight them in court. And in some states, there's additional financial downsides beyond that. Some states have what's called a civil penalty, where a manufacturer has to pay a penalty if they don't buy back a vehicle when they should have, or replace it when they should have. And those penalties can be substantial, sometimes to even double or triple the cost of the vehicle. So that's the other financial penalty that a manufacturer faces. Also, if they don't resolve a claim amicably, any consumer has First Amendment rights. There could be a news story run on their case and bad publicity for the manufacturer. So there's all kinds of downsides if they don't cooperate.
Yeah, it seems like they would kind of account for certain amounts of bad products, because it's just kind of how it is in all of manufacturing. What would be the advantage to them fighting tooth and nail to the end? I mean, do you often see them do that?
Well, with our firm, not often. We've defeated them in court before. It's kind of like back to the fighter analogy. It's like, if you're a professional boxer or UFC fighter, you don't really have to worry about getting into fights, because if you're known, people know that you're a legally trained professional and they don't want to risk fighting somebody like that.
Sure.
It's kind of similar in the lemon law context. If they know that it's a reputable firm where the attorneys have years of experience and they've defeated them in court before, the companies are not going to want that fight. But with that being said, there are several reasons why manufacturers would nonetheless reject legitimate claims. So let's crack into those. So first is like what I was talking about before. That's if you don't have an attorney at all. These companies know that even if you're threatening an attorney when you're contacting them on your own, they know that, percentage wise, and they deal in probabilities to kind of cost benefit, that maybe 1 or 2 out of 10 people who make that threat or who reach out to them will actually go the extra step and hire an attorney. And so they're just basically playing the law of averages. They're like, okay, well, we know most people are not, even if they're threatening it, are not going to actually hire an attorney or a law firm to go against us. So if we blow them off, or if we offer them something very minimal that's not even close to what the law requires, like a month or 2 of payments reimbursed, or a short maintenance plan, a few free oil changes, or say a short warranty extension of 3 to 6 months, none of these things are even close to what the law requires. But sometimes if they do that, people will just go away. And so they just play the law of averages when it's an individual consumer. That's why it's always in the consumer's interest to consult with an attorney if they suspect they have a lemon vehicle. Almost all the firms I'm aware of provide free consultations. And if a firm does not provide a free consultation, you have other options out there. Like us, we do offer free evaluations. And so if you do have an attorney, one reason why a company might reject a legitimate claim is some lemon law firms are what are called mill firms. And it's kind of like what it sounds. It's like, like a paper mill, kind of churn and burn. And so they are known to not ever file lawsuits. And the reason that they don't ever fight the manufacturers in court, well, there's a multitude of reasons. It costs time and money. They might not have a very good won-loss record. It's extra stress. So look, these companies, they're sophisticated. They know which firms will fight them and which will not fight them. So if they know it's a firm that won't fight them, they're more likely to reject a legitimate claim. It's kind of like if they know that you're willing to fight, even though 95% of our cases settle out of court, they know out of the 5% that don't settle, most of those clients do decide to sue, and they know that we are willing to sue in a legitimate claim. And so because of that, that deters them from rejecting legitimate cases. But if they know a firm will not fight them, then what incentive do they have to be reasonable? They might still, just as customer goodwill or something like that, still settle cases. But I can assure you they are more likely to reject legitimate claims if they know the firm will not fight them. What's another reason why a manufacturer might give a consumer a hard time, even if they have an attorney? Some of these companies have basically a zero-sum game mentality, and what I consider to be a very scarcity survival type mindset. And the way that they look at it is, if we're too agreeable, if we're too fair with somebody who has a lemon vehicle, then word might get out that we're kind of pushovers, and then more people will end up coming after us with frivolous claims. So they feel that by being difficult, they are going to deter those frivolous claims. And to be fair to that viewpoint, maybe it would deter some claims.
Right.
I still think it's very short-sighted, and here's why. If you have a lemon vehicle and you're dissatisfied with it, but the company steps up to the plate and makes things right, either buys the vehicle back, replaces it with a brand new vehicle, or at least compensates you fairly for what you've been through, for your inconvenience and for having overpaid for the product. If they do that, sure, word will probably get out to your family and friends. But I don't think that's a negative to the company overall, forest through the trees. And here's why. Because I think that most consumers, it's kind of like Pareto principle, 80-20. I think 80% of people are reasonable, are fair, are honest, and maybe 20% of people, to varying degrees are more difficult and might sometimes not have the right perspective on things. So if word gets out that the company is helpful, what I think really happens is that people who are considering the brand are more likely to buy it because they have that peace of mind that, hey, if this ends up being a lemon, the company is going to take care of me. And so I think, applying the Pareto principle, which it's kind of crazy, it applies to almost every aspect of life. Like, 20% of your work gets you 80% of your results. 20% of the people in your life cause you the most headaches, so on and so forth.
That I agree with.
But in any event, so let's say they get 10 extra vehicle sales, just theoretically speaking or hypothetically speaking, based on what happened in a particular lemon law case. 10 more people that would not have bought their product end up buying their product. And let's say 2 of those following the Pareto principle, because again, I do think most people have integrity, most people are honest.
Sure.
And are not going to bring any kind of frivolous claim. But let's say Pareto principle wise, 2 out of 10 do end up doing that. Okay, so you have to deal with 2 frivolous cases, which might take up some time and money, but that's way overcome by your 8 additional car sales. And so let's say in the aggregate, because obviously there's multiple clients and multiple claims throughout the year. So let's say in the aggregate, it's 100. So based on multiple clients. So let's say, so now you have 80 vehicle sales and you have maybe 20 frivolous claims to deal with. You're still coming out way ahead, in my opinion. So that I think is the correct way to look at things. And we try and persuade the companies of that. Like, hey, do right by this customer. And by doing that, you will have a lifelong customer who will buy your vehicle repeatedly, more than make up for what you're paying in this claim. And not just that, the people in their lives, friends, acquaintances, and family members are more likely to buy your product. And again, overall, it will be way more positive to you than the small percentage who might end up bringing frivolous claims. And look, even if a frivolous claim is brought, like if it doesn't qualify, like they have no leg to stand on, they're not going to get very far.
Very true. All right. Well, thanks for joining us on the LemonAid podcast with lemon law expert Shalev Amar. Please be sure to like and subscribe to our channel and leave us a review. Shalev, what's the best way for people to get in touch with you if they have a lemon law claim they'd like to discuss?
So we're in multiple states, and in most states we're under lemonlawadvocates.com. And so starting with Arizona, it's ArizonaLemonLawAdvocates.com. And then moving on to Washington, it's WashingtonLemonLawAdvocates.com. In Oregon, it's OregonLemonLawAdvocates.com. In California, it's actually California Lemon Law Advocate, NOS.com. In Utah, it's UtahLemonLawAdvocates.com. In Colorado, it's ColoradoLemonLawAdvocates.com. In Nebraska, it's NebraskaLemonLawAdvocates.com. In Nevada, it's a little bit different. It's NevadaLemonLaw.info.
I don't know how you keep all that straight in your head, but it's very impressive, Shalev.
It's been several years.
Thanks so much for being here. Really appreciate your time.
Okay, thank you, Mike. Thanks for having me.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.